Rafiza, thank you for coming today. We are pleased to inform you that you have been selected for our engineering training program.
Really? Thank you so much, Miss. I've been waiting for this opportunity for a long time.
The agreement includes a training bond and several important conditions. You are required to complete the program for approximately 4 years.
4 years? Okay, that seems reasonable.
During this period, you are expected to fully focus on your training. Any breach of the agreement may result in termination and repayment of training costs.
Okay, I understand. I'm ready.
Just make sure you read all the terms before signing.
Miss, do you have a moment? I have something to discuss.
Okay, have a seat. You look worried. What's wrong?
Actually, I want to discuss about the training contract. I just found out that I am pregnant.
Are you aware of the clause in your agreement regarding pregnancy?
Yes, but I was hoping that we could discuss this.
The clause clearly states that pregnancy during the training program is not allowed.
But I'm still able to continue my training. I can manage both.
This is not about whether you can manage or not. This is about complying with the agreement. The company has strict policies. We cannot make exception.
So you are saying that I have to choose between my career and my family?
I'm saying you agree to the terms.
Having considered the submission of both parties, this court is of the view that the central issue is whether there has been a breach of contract by the defendant. It is not disputed that the defendant had entered into a training agreement with the plaintiff, and that the agreement contained clause 5.1, clause 4, which expressly prohibits pregnancy during the training period. The defendant had voluntarily signed the agreement and is therefore bound by its terms and conditions. The court finds that the defendant became pregnant during the subsistence of the training period. This clearly constitutes a breach of fundamental terms of the contract. The agreement raised by the defendant that the clause is discriminatory has been considered. However, this court is of the opinion that the present matter concerns a private contractual relationship between two parties. This is insufficient basis for this court to invoke constitutional principle in determining the validity of the clause. In addition, the clause serves a specific purpose in relation to the nature and requirements of the training program, and therefore cannot be said to be unlawful or invalid. Accordingly, the court finds that the plaintiff is entitled to enforce the agreement, including the provision for liquidated damages. Therefore, judgment is entered in favor of the plaintiff in the sum of Rm92,000 together with costs. Is an appeal against the decision of the Session Court. Upon careful consideration of the facts and submissions, this court finds that the main issue is whether clause 5.1 clause 4 is valid or whether it is discriminatory and contrary to public policy. The clause in question applies exclusively to female trainees and imposes a restriction on pregnancy during the training period. The court notes that pregnancy is a natural condition unique to women, and any clause that penalizes such condition must be carefully scrutinized. In this regard, the court is of the view that the clause places an unequal burden on female employees, particularly to those who are married. Such restriction effectively compels a woman to choose between her employment and her fundamental personal life, in which raises serious concerns of fairness and equality. The court further considers Article 8 Clause 2 of the Federal Constitution, which prohibits discrimination on the ground of gender. While this case involves a contractual relationship, the court is of the opinion that principles of equality should not be ignored, especially where a term appears to be inherently discriminatory. In addition, although the Convention of the Elimination of All Forms of Discrimination Against Women, CEDAW, has not been fully incorporated into domestic law, its principle may serve as a guiding framework in interpreting issue of gender discrimination. Taking all these factors into account, this court finds that Clause 5.1 Clause 4 is discriminatory in nature and contrary to public policy, and is therefore invalid and unenforceable. Accordingly, the appeal is allowed and the decision of Session Court is to be set aside. Order, the court is now in session. This case concerns a dispute between the applicant and the respondent regarding a clause in an employment training program. The applicant challenges the clause on the ground that it violates her constitutional right, which is equality. The respondent, on the other hand, argues that the clause is a valid contractual term. Counsel for the applicant, you may proceed.
Much obliged, my lord. My lord, this case raises a significant constitutional question regarding equality and fairness in employment. The clause in question prohibits pregnancy during the training period, and this condition applies exclusively to female employees. My lord, the practical effect of this clause is that it places women at a clear disadvantage compared to men. A male employee will never face this risk of termination due to pregnancy, whereas a female employee must constantly bear that risk. This, my lord, creates unequal treatment based on gender. Under Article 8 of Federal Constitution, all persons are equal before the law and are entitled to equal protection of the law. The applicant submits that this clause undermines that fundamental principle. My lord, equality is not merely about treating everyone the same on paper. It is also about recognizing situations where a rule, although neutral in wording, has a discriminatory impact in reality. In this case, although the clause appears as a general condition, its effect is clearly directed at women. My lord, the applicant further submits that this honourable court should take into account international standards, particularly the Convention on the Elimination of All Forms of Discrimination Against Women, or CEDAW. CEDAW recognizes that discrimination includes any condition that restricts women's ability to exercise their rights equally, including in employment. The clause here forces the applicant into an impossible position. She must choose between continuing her career or continuing her pregnancy. My lord, such a choice should never be imposed by an employer. Furthermore, the consequences of clause are severe. The applicant was not only terminated from the program, but she was also exposed to financial liability under the training bond. This creates a double burden, loss of career opportunity, and financial hardship. My lord, we submit that such clause is unreasonable, unjust, and contrary to public policy. Even in private agreements, there must be limits to what can be imposed on an individual. Therefore, my lord, the applicant respectfully requests that this honourable court declare the clause is invalid and unenforceable.
Much obliged, my lord. The respondent respectfully submits that the applicant's arguments, while emotionally compelling, are legally unsustainable. My lord, the starting point of this case is clear. This is a contractual dispute between two private parties. The applicant voluntarily entered into the training agreement with full knowledge of its terms. There is no evidence of coercion, misrepresentation, or inequality or bargaining power that would invalidate the agreement. My lord, the applicant is attempting to transform a private contractual matter into a constitutional issue. However, it is well established in law that constitutional provisions, including Article 8, operate vertically. That is, they regulate actions of the state and public authorities, not private individuals. Therefore, my lord, the applicant's reliance on Article 8 is misplaced. With respect to CEDAW, the respondent submits that although Malaysia is a signatory, it does not automatically form part of domestic law. In Malaysia, international treaties must incorporate into legislation before they can be enforced by the courts. As such, CEDAW cannot be directly relied upon to invalidate a contractual term. My lord, turning to the clause itself, it is important to emphasize that it does not permanently prohibit pregnancy. It merely restricts pregnancy during a limited training period, which is essential for the completion of the program. The training program requires continuous attendance, focus, and physical capability. Any interruption may compromise both the training outcome and the company's investment. Therefore, the clause serves a legitimate and reasonable commercial purpose. If such clauses are not enforced, it would create uncertainty in contractual relationship. Employers would be unable to rely on agreed terms, and this would undermine confidence and commercial arrangement. So, the law must protect certainty and uphold agreements that are freely entered into. In this case, the applicant accepted the benefits of the agreement, and she must also accept its obligation. Therefore, my lord, the respondent respectfully submits that the clause is valid, lawful, and enforceable. The termination was carried out in accordance with the agreement, and the claim should be dismissed.
My lord, the respondent cannot justify discrimination by calling it practical. The effect of the clause remains unfair to women.
My lord, the applicant is attempting to avoid a term she had agreed to. The law must uphold certainty in contracts.
The court has carefully considered the submission of both parties. The main issue is whether the clause in the agreement violates constitutional principle of equality. The court finds that the agreement was entered between a private individuals. Constitutional provision generally applies to action of the state and not private individuals. Therefore, the clause cannot be invalidated on constitutional grounds. The court further found that the clause applies only during the training period and does not permanently restrict the applicant rights. Therefore, this court has set aside the order of the High Court and the claim is to be dismissed. While the outcome may appear harsh, the role of this court is to apply the law as it stands.